He is not.
Respectfully, if you interrupt me again, you
years.
will be picked up and put in lockup for contempt. All right, there you are, sir. All right. This is docket. I'm sorry, this is Anthony. Yep. And there's two. Are there two files? I only have one listed. Is the final pretrial on both or on one?
It's just on the one, Your Honor.
All right, thank you. This is docket 23131 FC, People of the State of Michigan versus Carlos Lee Anthony. Counsel, your appearances for the record.
Good morning, Your Honor. Michael Dobie, P76671 for the people.
Thank you.
Good morning, Your Honor. Ron Berry appearing on behalf of Mr. Anthony, who is standing to my left or right at the podium.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide you the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
You put your hand down. Thank you for wearing a suit. I rarely see defendants wearing suits, so I appreciate that. Okay. Have you taken any medication yesterday or today?
No, ma'am.
Alcohol, marijuana?
No, ma'am.
Are you supposed to be on medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
You had enough time to talk with your attorney?
Yes, ma'am.
And has there been a plea offer in this? This is a final pretrial.
There has not been, Your Honor, in discussion with the defense attorney.
Sorry, sir. You need to stay closer to your mic. We can't understand you.
I apologize, Your Honor. No, there has not been a plea offer made in this case. In discussions with the defense attorney, it was made clear that the defendant would only accept a misdemeanor, so there was no real negotiation beyond that.
Counsel?
First of all, I don't discuss the subjects of our negotiations. We had a conversation. I don't know that I ever said that he would accept any offer, let alone whether it's misdemeanor or felony. In this matter, he maintains his innocence, and we've negotiated as such. Where we're at right now is Mr. Dobie had indicated to me 3 months ago that he was going to follow up with law enforcement about getting discovery that's outstanding, and I haven't heard anything since. We don't have the body cameras, the motor vehicle camera videos, anything of that. I understand this is the AG case was transferred to the AG's office from William County.
Wait.
But this whole we don't have it.
Stop a minute. This is a 23 case. Sir, how is it this information has not been given to counsel? 2 years, 3 years. What's going on here?
Your Honor, a lot of the things that he has requested simply don't exist. 4 body cam videos were located by a subsequent search by the detective sergeant now
A subsequent
on the case.
You gotta stay next to the microphone. So you said a lot of what he's requested doesn't exist. And then what did you say?
4 additional body cams that had not been previously provided to my office were provided. They have been provided via a download link to Mr. Berry this morning.
Via a what? Oh, via what?
A download link, a link to download.
Download link. Okay. So, is there outstanding evidence that you have not provided to defendants in 3 years?
No.
Are you?
Well, frequently, Your Honor, I'll have to talk to Mr. Dobie to find out when this stray email must have been sent for me to download some additional body camera. It's interesting. I'm being told that much of it doesn't exist, which what I'm asking for is body cameras and dash cameras. And then in the same vein, being told 4 body cameras are sent to you. I don't know. I guess I'll have to look at them. But I know there's lots of law enforcement that were involved with this. They're referenced in the police reports. And to be simply told they don't exist, I want to get some follow-up on here. I guess I'll have to file a motion to compel, and we can get evidence.com records to prove whether or not they exist and what efforts Mr. Dobie has taken, if any, to actually retrieve them.
Okay, I have a solution here. And Court of Appeals is down the road if neither one of you like it. So today is the, what, 26th? No, yeah. They're looking at February. My brain's already February. Today's the 28th of January. Whatever's outstanding or whatever, can this be figured out by February 4th?
Oh, not that quick, Your Honor.
Why not?
Well, I currently have another.
Don't care. Because they have to come up with it, not
Okay,
you.
there's only one me, and I have lots of words.
I know you do.
So
I know you
that
do.
quick, I cannot.
Wait a minute, you have a list of what you need, right?
Yeah.
Okay.
Well, I mean, I don't know what exists. But all police.
Not your job.
Yeah.
Not your job. Sir, turn over everything that exists.
Yes, Your Honor. That's happened.
You can go through, it's gonna take 10 seconds. You could do it right now. I'm happy to wait. You can go through your email on your phone. Just don't say anything yet. You can go through your email on your phone, whatever, and look, and if you never received it, I'm inclined to dismiss this.
Well, that part we clarified.
Okay.
He gave me back in November a download with 172 files. We had a screenshot,
Okay.
and I confirmed with him that I have downloaded those, and that even in his own material, that those do not include law enforcement recordings. He's at least providing an update that there apparently he found 4 police videos. I don't know. He's never emailed or communicated with me about that. But if there's a download,
when did
I'll
you
download.
find those 4?
I'm sorry, I didn't find them. The detective sergeant now, I have no access to evidence.com or whatever the Lansing police use.
Oh,
But the additional 4 videos, so the entire Red Prince 176 items. So sending everything again was sent this morning to Mr. Barry, like within the last half an hour.
Oh, so the
me-
4 additional cameras were sent this morning, and I've received no additional information. Okay, now I understand.
okay. Let me understand.
They didn't exist before this morning, apparently, Your Honor.
How long has this? Here's what we're doing. This case is dismissed.
I'm sorry, Your Honor. There's been no motion to compel. There has been you're dismissing these because only
I'm
because
dismissing these, so
Mr.
you go
Barry
get your
says
act together and you can reissue it. This file is 3 years old. This man is due a speedy trial, and this information is not new. I rarely do this. I can't think of one time in 22 years I have done this, but this seems to me to be unfair and prejudicial, and you can reissue. You can take your time and reissue when everything's put together, and then we're gonna do all this again. And am I causing taxpayers money? Yes, but you know what? This man has been reporting to pretrial services for 3 years. The date
Your
of
Honor,
this offense
respectfully,
was,
he is not. This
respectfully,
has
you
been on
interrupt
2
me again,
years.
you will be picked up and put in lockup for contempt. So I'll give you a chance to talk, but you will not interrupt me, especially when you're on Zoom, and I've given you the courtesy to not plow through the snow like everybody else, and you're on Zoom. This offense occurred February 15th, 2022, and I am not a judge who just dismisses things lightly. And you can ask everybody in this town, you can go down to the Court of Appeals, and you can do whatever it is you want. But this man has been under our charge for 3.5 years or so, and things have not been turned over until now, and now I'm hearing they need more and more time. There's constitutionally protected rights. When you all get your, and there's no statute of limitations on a life offense. So when the Attorney General gets their act together, so will everyone else. This is dismissed for lack of progress and prejudice.
Your Honor, I
That is
need
my
to make
ruling. Court of Appeals down the road. Yes?
Can I make a record here, Your Honor?
You can make whatever record you want as long as it's respectful and don't interrupt me again.
Absolutely. Thank you. Yes, Your Honor. This case was charged by the Ingham County Prosecutor's Office. It was almost a year
I'm
before
sorry, you
the
have to stay,
AG.
sir, it's my court reporter, you gotta stay near your microphone. The Zoom, for whatever reason, is not picking you up very clearly.
Thank you, Your Honor. This case was originally charged by the Ingham County Prosecutor's Office. It came to our office approximately a year after that. For about a year and a half since I've had it, the defendant was on bench warrant status, not reporting. He is, despite repeated violations before and after that. I don't believe that there
What
is
violations
any
after that?
I don't believe that there is any basis for dismissing
Just a
this
moment,
case.
sir. It dropped after bench warrant status.
He was on bench warrant status, not reporting.
Yes, Your Honor. He was on bench warrant status following a violation. He was just on the idea that he has been reporting to pretrial services for 3.5 years. That's not accurate.
Well,
I
let
don't
me
believe
just
that there
say
is any
this.
basis for this
You just
dismissal
gotta start
based
again.
on the
Sir, you
defendant's.
gotta start again. The court reporter's not picking it up.
Your Honor, I don't believe that there is any basis in law for this dismissal based on the defendant's claim that there is additional discovery that has not been provided.
Sir,
There has been no order to compel, no motion to compel, and no showing that there has been any wrongdoing by any party here.
okay. The bench warrant that I have was in 2024. We are in 2026. The first witness list that I have here from the people was in 2020, let me see, 2024, August of 2024. This is a final pretrial. My expectation on a final pretrial is that you are all ready, not that we go back to square one like when he was charged. And you certainly can file a motion for reconsideration or do whatever it is you want to me, but this is truly unconscionable here. In August of 2025, he was held in contempt and served 17 days. So between August and now January, there was plenty of time for this evidence and the files from both sides to get in order. I don't know why we're at final pretrial and now there's claims of things that have been in possession of law enforcement and the Attorney General, and I suppose the Ingham County prosecutors for all these years and not been turned over. So as far as I'm concerned, a lack of progress is violating a fundamental right to presumption of innocence and freedom. And believe me, I don't do this lightly. I understand these are life offenses. They're very, very serious. But so is the lackadaisical attitude, maybe on both sides, maybe on all sides. I don't know, but I'm not going to stand for it. The resolution is to either file a motion for reconsideration or simply recharge defendant. No, we're done with this file.
Your Honor, may I ask the court issue the order so I don't have to worry about an objection, 7-day rule and all that?
There's one right there, print it. We'll send it over to him and I'll sign it. Just do the blank one. I'm not, so sir, I suggest, you're not skipping town, you got another file in front of me. I suggest that you are the most law-abiding person on the planet. I don't like what happened here. I don't like these charges. I don't like this whole situation. But you do have a right to a speedy trial and a right to have an exchange of information that is timely. And this is simply disturbing. And I know everybody's busy. No one knows that more than me. And I had 100% criminal docket. I get it. But this speaks to laziness on your part, your counsel's part, the prosecutor's part, the Ingham County prosecutor's part, and that's not a justice system. That's a lazy system. That's not what I'm gonna tolerate. So message sent, they may very well reissue, so I suggest that you deal with your attorney and maybe you continue working on this. I really don't know, I'm not giving you legal advice, but they do have the option of reissuing this immediately, and they can do that. But message sent, I hope. That is all. I'm gonna sign the order. We're gonna, counsel's writing it. We're gonna send it to you, sir, for approval, or I'll just read it now on the record.
Yes, Your Honor.
All right, this matter is dismissed without prejudice for the reasons stated on the record. Any objection to that, counsel?
No, Your Honor.
On behalf of the Attorney General?
None beyond what I've already stated.
Great, send a message to your office. I expect timeliness, especially on a final pretrial. Y'all get your ducks in a row or this will happen. I don't know what else to say. I have not done this in 22 years. But this does not sit well with me. Well, make sure you all get a copy of this. That's all for this record.
Thank you, Your Honor.
Counsel, you have a next date on the second file? I hope.
I believe there is one, yes, Your Honor.
All right, thank you.